So let me start my presentation and then we can discuss along the way as well as after the talk is over. Hello, so having been instrumented, good morning again. This is getting recorded. So as I mentioned, let me first share with you the thoughts and experiences of mine, and so I thought it would be good to talk about this, that because I think all of you must be having, actually some of you have started filing patents, but even after doing that, sometimes we just move in a current, in a flow, we just keep doing what others are telling, others are doing, and others are talking about it without being internally convinced, right? So let me ask those questions and hopefully I'll be able to make you think that so the organization is like this. You can just, like my earlier talk, which was originally meant for students, then customized for young faculty, and this is also the same. In fact, this is one of the talks I gave in earlier version. I have now revised it a little bit. Actually, was given to me, as far as I remember, 12th March 2020. So that was my last physical talk given before the COVID, and so in fact I lost track of it. Then later on I recovered it recently from my email. Somewhere I know I probably mailed it to my students or something, and I got it back because it was not in my archives. So I'll try to explain what is a patent. Actually, no, I'll not spend too much time on it, and there will be formal discussions, formal presentations on details of patent, copyrights, trademarks, and things like that. So, but I'll try to explain in my own way, and then the steps of how we really go about writing the patent, and what happens after a patent is filed and it's granted, and then my thoughts on when you should file a patent and when you should not, and then what are the mistakes to avoid, and then we come to the final question: why should an academic or an academic institution, right, why they should file, right? And then of course I will be open to your questions and all. So let me not read through, let it be on the screen. So basically patents are give you certain right. If you have a patent on something, you have a right to use that for commercialization. And if you are having a patent, nobody else can use that same idea, same design to say create an instrument or to even use it in a software without giving you the credit. So if they have to do it, they have to give you the certain fees based on whatever you want. Similarly, copyright is also something, I think we understand copyright in a better way. So suppose you are a poet, right, and you have written a poem. Nobody can use that poem in a movie or in another drama without informing you or without giving you the credit. Of course, you are free to give it free of cost. That is up to you, but they must take your permission, right? The same way, the patent is also to be enforced like that. If you have the patent, then you can enforce that right. And one more thing, that is a common mistake, we feel that patents can be international patent. Actually, there is nothing like international patent. Every country has its own patent rule, and China has none. So if you actually give something to China, they will copy everything without giving you a penny, right? So even if you have patent in India, patent filed in India, it will not matter because you cannot sue that company in a Chinese court, right? So that was an issue. So what happened is that this PCT came up, about 50 years back, where certain countries where they agreed to respect each other's patent, in the sense that these countries which are signatories to it, like India, US, and most European countries are signatories to this patent control treaty, patent cooperation treaty. they say that in all countries the rules will be similar, right? And if you have filed a patent in one country, the other country will take cognizance of that, right? It will not prevent another party to patent that in that country, but that will be there will be with a rider that look, this thing has already been patented in India and US and somewhere like that. So it will be recognized as a kind of a deterrent, because whenever somebody files a patent and then it's expected that that team is also working further on it. So it is possible that they can actually, and suppose you use that patent, that Indian patent as a base, and tomorrow there is a derivative patent coming out of it, right? They cannot use that derivative, right? Because and suppose the derivative patent is actually protected in that country. So people, if they track this development, they can easily catch you. So suppose just for example, in France, somebody is using a patent which is published in India without any negotiation or anything, and tomorrow you have a better thing, right? Which then, because you see that this person has already is already using your Indian patent without giving you money, you file that patent in France, right? So then, if you get that patent in France, that other party cannot use that upgraded one. Then they have to come to you. So basically, it is a kind of rules of the game, right? Through this cooperation, people are trying. The countries have tried to prevent misuse of patents, right? So these are 2-3 things that I thought I'll tell you. Sometimes these are also not known so much. So as I said, it is not an international patent. Just having you sort of report your patent to the PCT. So many of us do that. Right? If we feel that some patent has international applicability, then we file it so that gets recognized throughout that community, right? And it recognizes your right and commercial right in particular territories where you have actually filed. So this part actually I will not go into too much detail today, because each patent has to be written in different ways, and you have a workshop and other discussions coming up. But one thing I would like to mention, that whatever is the way that we write our research papers, in the same way you have to write the patent abstracts, right? That is what is already existing in the world. In what way is our thing different from that, right? And what is novel? What is novel in the approach, right? In what way it differs from the existing state of art. Now, these two things, as you can see, is exactly similar to that of a research paper. So, where is the difference? The difference is that in patent writing, you have to very clearly articulate, right, your novel features, right? In research papers also we do that, but we can get away by by a lot of smart language. While we are filing a patent, you can't do that, because patents you have to be very, very crisp that this is the novelty, right? So what is the novelty, right? Is that in the earlier research work, the glass of water was kept here, right? And or let us it was kept here, and there, or let us say put it was kept in the corner. Just give a very silly example. So it would have fallen down, and then it might have got spoiled. But in my patent, I have kept it in the middle, so it is safe from both sides. Just give a simple example. So you have to say in what way it is different and what impact does it make. So it has to be novel, certainly. So novel means, if you move it from here to here, you can say it is novel. So everybody else was keeping it like that, and you have to say that it should not be very obvious, right? That okay, everywhere, any common person, suppose is looking at it, they'll tell, no, it may fall down. So they themselves will keep you there in the middle. That is very obvious. So it should not be very obvious, in the sense that no, you don't do it, but you make a you have to make a structure, and that structure will be such that you can keep it on the at the side also, or accessibility or something, and also it will not fall down, and that structure is novel, right? Nobody thought of it. No, it is made of a new material which is some new aluminum composite or something like that. I'm just telling very in a random way. So something like that. So that thing nobody thought about. But maybe in a more application like that, suppose you are it's kept in the moving train, right? So in the moving train, you often see that the train is moving and the water bottles which are kept there, they just fall down, right? So that structure, if it is kept in the train also, it will not fall down, right? So it will be a bowl-like thing, and then in that you put the water bottle, and it will not fall down because the way the liquid will maintain its balance, right? And then it will be a solid. It will never fall down. It will be always vertical or something like that. Okay. So that way you have to clearly explain the novel feature, and also this last point, application, is actually sometimes misunderstood, and also in terms of even we as faculty members, we often misguide the students, saying that if your result is not better than anybody else, then you cannot patent it. So that is not true. Your result need not be better. Result needs to be different. And who knows, tomorrow that result may turn out to better in some application, right? Because it depends. You may say that okay, this material or this product which you have made is actually having a very expensive material. So this will don't patent it. There is no use because this material is expensive. But tomorrow, what may happen? That material become cheap, or you may have the same technique applied to another material, and you will get a better solution. So as long as novelty is there, we should encourage. We should encourage and file patents, right? And filing patents doesn't mean that you will get the patent always, but still it is better than not filing, in the sense that tomorrow you want to tomorrow suppose it gets applied somewhere and you have not filed a patent, then that company or whoever is using, they do not need to give you any penny, because as soon as you file a patent, then next day as academics we would also like to publish, because we don't want to we can't afford to keep things unpublished unless there is very good reason. So we will often publish and people will come to know about it, and they can simply use that. But if you in your paper you write patent file somewhere, then people will be cautious. They will not take it for granted. So these are the things you have to keep on. I'll keep on highlighting that from time to time. And so these are the things. What solution you are providing in whatever is different from the existing. As I said, different. I am not saying in what way it is better. That is a different question. That only future will tell. No, 20 years later, something may be better or not better. But today it is different, and tomorrow it may be useful in some context. Right? So it is actually, it's a kind of know-how. People develop things and based on and develop some know-how. So this is different from the know-how used by another developer. Right. Now, this is the reason, what happens after the patent is filed. That actually, discourages people from filing a second patent. Once you file one patent and see the amount of time it is taking, you feel discouraged, and in fact I myself did that. After filing a few, almost stopped filing because nothing was happening, right? But now the situation is changing, that also I will tell you, and so we must note that. So what happens is that patent will be normally published after 18 months. But it can be expedited by paying additional fees. And I was very happy to hear from Professor Dubey that last year we have paid, IIT has paid for 130, 125, I mean same, okay. A large number of patents we have asked for expedited examination, and then it gets published much earlier, sometimes within 6 months also, right. So getting the patent published is the first step, right, and we are expediting through additional expenditure, and government is also expediting. Government has now started putting a lot of effort and resources. So after that there will be a request for examination, which is what we want to expedite, that it should be examined by the patent attorneys, I mean attorneys at the government, right? And that Indian Patent Office carries out the examination and then reverts to the attorney. Attorney means we will have, IIT has its own patent attorney, patent agent, so it will refer to them. They generally they deal with the patent office, and then the attorney takes the help of the inventors to answer them, right? Because they are the kind of middle men only, they don't know what is actual innovation. So they write, typically this is what happens, the agent will write to the faculty member, the concerned team, students, faculty members, whatever, and then they need to get an answer within a certain deadline, right? They will also tell you typically 6 months, but if you want to expedite, you should have it faster. So they give you enough time also. But what happens that we all often lose track of that invention, right? And if it is answered, then again there could be, if there is further objection, then they say what is the hearing, right? It's a legal term because patent is actually a legal right that you are going to exercise. So it is a legal term. So if the hearing goes on well, the patent is granted, otherwise the patent gets rejected. Now, as I said that typical time used to be 4 years to 10 years, but now it has come down quite a bit, and in fact now these days I think it could be maximum is 4 years, sometimes it's happening, and people are getting patents granted within even 6 months. In fact, within IIT I have heard that somebody, I don't know whether the faculty member is present here, but he told me that he got it within 6 months, 6-8 months. So that's very good news. So these are good things. So what is that we need to do? So we have to think of our one more thing that also is very, very important is about what is called annuities, right? So if a patent is granted, you will have rights up to 20 years, right, from the date of filing, right? So what used to happen, like I had my own experience where some patent got granted after 14 years, right, and then patent office said you pay so much and all that for maintaining the patent. Now something is not known to you within 14 years that you are going to get a patent, obviously you can't do much about it, and after 14 years the technology generally becomes obsolete, right? So that doesn't help. But if you get your patent granted within say even 3-4 years, then still there is a lot of business case. So if you want to retain your right, then basically what is called is to keep the patent in force. If you have to keep the patent in force, then you have to pay what are called as annuity fees, right, to the government. From the 3rd year, first 2 years the annuity fees are 0, right, and from 3rd year onwards the annuity fees start and keep getting increased. I think from 4,000 to 6,000, 10,000, 15,000, something like that. So this is where again the institution and the faculty members will be at loggerheads, in the sense that institute will probably write to the faculty, we want to keep this patent in force, please arrange for this fund, right. So that is again becomes difficult for faculty members because they might have done some project, filed from that project, now fund is not there, right. So mechanism must be found out, right. So maybe use from PDA and things like that, CPDA, certain things can be done. I don't know whether this rule is there or not. Now institute is paying. That's very good. So if institute is paying, no problem. So I think these are good things that is happening. So you must take advantage of that, because I can tell you in bigger institutions generally institutes don't pay, because also you have to see the number of files patents being filed. 400, 500 patents being filed, and each one the institute has to pay the annuity. There will be a big drain on the budget, but it's very good. IIT BHU, and I think we'll keep on doing it at least for some years until we find probably more sustainable way of doing it. Okay, so sorry. So this one, this is what actually you get. You get a patent certificate, right? So, and in between, if you want to know the status, you can check out from the patent site, and then this is the point ultimately that you can commercialize your patent, right? So either by licensing, or you can even sell your patent. You can, often what happens sometimes, suppose you have developed something which is very essential for another company, right? Let us say, I know about say electrical engineering. There is a power electronics circuit, right, which needs to be switched in a particular way. And suppose General Electric comes and says that no, I want it. I want to incorporate it in my product, and I don't want anybody else to use it. And also, I want it in my patent portfolio. Then process seeing who is the inventor and says, give me this much, and transfer the patent in your name, right? Of course, with the approval of the institute against substantial fees, right? Okay, so like that. You can, or you can do licensing, which is normal. Licensing is that you can give license to the companies for using your patent in their product, which could be exclusive license or non-exclusive license. Exclusive license means we will give it to that company only. The same thing, we can say we can negotiate with General Electric, say that no, we will give you exclusive license. Sometimes they will not be happy. They will go for they want the patent because then it will be in their control. Right. Otherwise, again, if it belongs to say IIT, another party may sue IIT and then get that patent away from IIT by defeating IIT in the court. But if it is General Electric's own portfolio, right, then they can defend it themselves. They will fight it out, right? So General Electric may like to have exclusive rights, right? Or they may say, okay, no, I don't mind others using it, so you give me a non-exclusive right. I will use it in my product. I don't mind if others use it in their product also. Then you can give it at lesser license fees. So these are the mechanisms in which the patents work. Now we come to the fundamental question. When should you file a patent? So typically what happens is that we have our research students, master students are working. So generally as they work, we keep observing, we keep monitoring, discussing with them, right? So when we find that there is a new idea, novel idea, which seems to be working. Sometimes people say that you must develop something, build something and make it work there. That is not necessary. Again, it's a question of your conviction. Right? So if you feel that whatever you have developed will work in practice, generally we can try it through simulation. Then you can patent it. In fact, theoretically we can also file patents on our own, with our own money. So there nobody is going to stop us. Suppose we think that we have got a new idea, nobody believes, let us say. Still I believe, I can pay that 4,000 or 6,000 rupees of patent fees and file a patent individually. But when you come to think of an institution and you are using the government money to file a patent, then you have to be a little bit more circumspect, in the sense that anything and everything we should not try to file. So we must have at least a validation. We should have a validation of our concept. As I said, you make a structure in which you put the glass of water which will not sway with the motion of the train, right? You should have some validation, right? Preferably you do that, you build it, test it in a moving train and see that it is working, right? Or in another case, so there is a simple experiment, maybe you can do it. In another case, it may involve experimenting with some nuclear reactor, right? Which you not get a chance to do. So you have to do a lot of simulations, etc. And then based on that, you have to be sure that it is going to be working. And then this should have what is called as a inventive step, right? So this is again what I said. What is the inventive step? Inventive step is something which will be even your patent agent will, when you are trying to file a patent, they will ask you the questions and will get the answers from you, because you are the best judge of whatever you are trying to patent. Is that what is that you have done which is not obvious to a person in your business or profession, right? So for an electrical engineer, they'll say, okay, so what is that novel idea you have done that another electrical engineering, say, graduate from, let us say, from IIT Delhi, will not find it obvious, right? ये तो होगा हमारे क्लास में पढ़ा गया है तो होगा, it's very obvious. तो ऐसा नहीं होना चाहिए. So that is what you have to be very clear about, that it should not be very obvious, right? That you start developing something, so suppose you are going on the road and you encounter some obstacle, you go to the left or the right. That is obvious, right? So, but if somebody says no, you have invented something which will make you suddenly jump up. You have say wearing your developed shoes, right? Which will make you jump up, then cross the obstacle and get down on the other side. Then this is not obvious. Nobody can do it so easily. No, at least I do not know how to do it. So that should be the kind of argument you have to give answers to. Right? So not obvious, or someone who has good working knowledge in your area. So you cannot say no, those क्लास में जो फेल हुए वो उसको पता नहीं है. That is not enough. So this person should be a proper graduate or something. He has passed the course. A proper knowledgeable person, right? Should not know. And then you feel that there is a possibility of making some money by licensing or selling your patent, right? So this is what, as I said, institutes will certainly look into this. Otherwise, see, you may or may not believe it, but all persons, or especially those who are in academics and research, they are capable of filing 100 patents per year in terms of ideas. The only saving grace is that you don't have time to work on all of that. So you work on 2, 3. That is good enough, but you have to go some further. That is why you need a student, a PhD student, master student. They work on it, they make it work, right? So this is why we have to be little bit careful in the sense that. But let me tell you that at this point of time, institute will not be so critical in terms of this money making, right? First, let us get into the habit of doing it. So we need not be very, very, pushy about, kitna $1 million milega. We don't want to ask you that question, but as long as we satisfy this requirement, as I said, this is not a requirement. If you are going to pay, suppose you are very passionate about some new idea, which may have nothing to do with your field also, right? But you may like to patent it, right? Sometimes what you can do, that you ask for no objection from the institute, right? That I want to file it on my own and with my own money. Please give NOC. Suppose institute refuses for some reason, you can do that. But if you are passionate, a few thousand rupees only, you can still do it with an NOC from the institute, right? Maybe tomorrow you will become a millionaire, then we'll keep it. We'll then ask for the rights. Right, we'll negotiate with you. Okay, so this is one thing. So the last point. So this is one. And then also there are reasons where we should not file a patent. Right. So as I said, no validation of your idea. Suddenly in the dream, in the night, I got an idea, and next morning, I want to patent it. Don't do it. Right. Right. You try to do some validation. Again, something, it should be obvious to someone. So again, this I always feel that you should bounce it with colleagues, students, right? So, and we should not be possessive about every idea that we get, because I have been there is a phrase called, ideas are a dime a dozen, right? Ideas are actually not that scarce. Everybody gets ideas, but the point is to get a workable idea, and more challenge is to make it work, right? So we must give priorities accordingly. If you have a workable idea which you have at least partially made to work, then then only you should file. And sometimes people do talk about this constraint, and what is this serious constraint in the academic context, because the students' submission and papers, they are all very, very relevant. But the fact is that if you file a patent, from the next day you can actually submit it for a journal paper, journal, conference, whatever. So there is no restriction. Once you have filed a patent, you can again use it for publication, and there are some benefits that also I will tell you. But then there is a very noble thing. If you feel that no, I don't want to patent. I want to give it to society free of cost. It is my idea, but I don't mind if everybody uses. Often happens in let us say in drugs, medicine research, right? Many medicines are actually just given away without patenting, right? So that's also a noble thing. You feel good about it, and ultimately that you have to feel good about it. Whether by giving it to people you feel good, or getting $1 million you feel good, it is your choice, right? But that doesn't mean that you will not file a patent. What I feel is that you can file a patent, get it granted, again then you donate. That's what smart people do. Right? At least people will know who has donated. Otherwise, ठीक है, some कुछ ड्रीम आया उनका, तो उनका ड्रीम से मिल रहा है. Right. And then again, so I have written that one, that not responding to the queries. Right? This is the most serious mistake that we do. Right? We don't respond to the emails. I have missed a few patents by that, and a few things also happened during COVID and all that. So there is something you. So often happens is that you leave the organization, right? Then mails will not come to you, especially for students. Students have left, and the faculty also, is not able to coordinate with them properly. They are too busy. They have left the country, all that. And also happens sometimes. There is also it's an interesting thing that sometimes when you are not fully ready with all the results, you can file what is called a provisional patent. And within 2 years from there, you can file the final version, right? So sometimes we forget that we have filed a provisional patent, right? And of course, losing interest down the line is also there, right? Especially when there is a long time gap. So, for example, I started filing patents on power management ICs in around 2008, 9, 10, around that. Probably filed about 10 patents or so, and then from 2014 onwards, I basically shifted to other areas. So I didn't have so much of need, and also in that area is also such that in 3-4 years everything gets obsolete. So the kind of loss of interest, which also, as I said, so I deliberately ignored few emails. And the last one, as I said, too far away from the technical field, as in my case, and maybe so for others also. So basically, losing interest is the main thing. So if we don't lose interest, and now that the time span is shortened, I think we can do a better job. Okay, there is another risk, is that you will not get a patent if you have disclosed it outside your organization without signing NDAs. Right. So suppose you are invited to an industry and they feed you well, of course, and based on that you give them all the information. Then tomorrow in your patent you will have to answer filing. I will disclose it to some parties. You can disclose it with non-disclosure agreements. So if you are going to industry and giving talks, be careful to avoid those ideas which you are trying to patent, or if you do disclose, make sure that you make them sign the non-disclosure agreement. If it is under NDA, you can do it, no problem. Now question. I mean, now coming to each of us, academic, right? So I feel this is the main point. First point, you feel good, just like a good journal paper, you feel good. Patent also you feel good. It will come on your CV also. So you can say I have 13 patents, I have 40 patents, whichever. So it's like it's a measure of your work, of your academic and innovative work, right? So this is one thing. So nobody can take it away from you, right? This is what you is guaranteed. Now in some organizations, granted patents are considered equivalent to a journal publication, right? So I am not sure what is the situation here right now. It is not considered, but I am sure we should review that. Each granted patent should be equivalent to one journal publication, right? And we can see other options. So this another point. This is a very important point, and which is valid even if you don't get the patent. It makes you think very clearly about what is the novelty of your work. As I said, even in journal papers and all, you are supposed to write those things. Now, what happens in journal papers, we sometimes, as I said, get away by clever language here, that way, that method is this method is this, my method is this. We somehow manage. But if patent, you cannot really do that. You have to be very, very clear. So, if you have filed a patent, then you must be having something which is very uniquely you have already figured out. And converting that to a journal paper, in fact, all my patent applications, of course my students, right, they got converted to IEEE transactions, top IEEE transactions, without effort, often without much major revision or anything. Because revisions come because of that. People will say what is the novelty is not clear. Now if you have filed a patent application, you already know and you have already written one document about the novelty itself. So that part takes care of the introduction. That patent writing exercise takes care of the introduction, which is the most vital thing for making the reviewers understand the worth of your work. So once you have got that, of course, all equation results, everything, they will be there. They have to be there. But basically, putting your work in the perspective and in terms of novelty, always you get a one little benefit by writing. So even later on, for some reason, the patents gets rejected. Some reasons, so many reasons could be there. Somebody has done it 2 months before and things like that. Or they file that exactly same thing has been done somewhere else. Right? So as I said, so let me clarify. Yes, you can communicate papers to journals and conferences after filing the patent. Actually, the rule is that you can probably do it with 6 months of submitting also. Suppose you submitted paper, up to 6 months from there, you can probably file a patent, but why take the risk? First file the patent, right? And otherwise, once you send the journal, your motivation to file the patent will go down. This is what happens. So better file the patent, and filing a patent is hard work. Let me tell you. So people will be reluctant to take it up again after writing the paper. But if you say your journal paper you will submit only after this, you put it on yourself in whatever way you do. So this will always force us to file it, and as I said, writing the patent is very illuminating. It will give you much more edge. So the last one I have cut, but I have deliberately kept it. So let there be little thought, then maybe one day I will become a millionaire. Dream में रहने से भी ठीक है. It may not happen, but सोचने से कोई गलती नहीं है, सोच सकते हैं. तो होने का chances बहुत कम है. Because what happens is that yes, some people do make millions by the patent, but it's a matter of luck. So out of 100 patents, right, one may be such, right? And companies, so I'll come to the companies or organizations, they can make, or no, so like this. Two major good examples are Stanford and MIT, because they have such a huge patent portfolio that some of them, and they actually, of course, and also the faculty and student base, so many of them are contributing, and some of those ideas are actually going to the industry. So if you do not file, right, they have no way of making money. But if you file, out of 100 patents, even one patent making money, they will recover on the entire cost. Cost of filing 100 patents in US, it's about 1 lakh rupees or so. So $10,000. In India it is 1 lakh rupees. It is about $10,000. So 100 means 100 into 10,000. That means 1 lakh, 10 lakh, $1 million. Right, $1 million for filing 100 patents. So one of them makes money, it may be making, who knows, $100 million. Right. Of course, depends on the contribution of that patent into the bigger thing. But millions of dollars are in, or billions of dollars are there running in the business, and they get a lot of their earnings. They are both private universities, but they earn more from their technology transfer from any other government funded projects or anything, and that is how they can even give free studentships to their students and all, tuition waivers, all from that type of money. As I said, one successful commercialization, and also it encourages industry academic interaction, right? So what happens is that suppose industry comes to IIT, so then somebody like Dean R&D or departmental head, they will come, first talk to them, and step by step they will talk, and then whatever is of their interest, they may be able to find one faculty. But suppose you have filed a patent which is published, and not be granted even, they can look at that, and then it will actually attract the industry to you, right? Rather than you going to the industry, you will go to how many places, and they also can go to only so many places. But if you find that somebody is having patents, particularly, what is a better thing, better than having a single patent, is called a patent portfolio, a portfolio of patents, right? So again, I know about power electronics, so let me give that example. So you have a patent on some inverter, you have some patent on some switching scheme, you have patent on some control of that. So like that, different aspects. They have a very well-rounded patent portfolio. So using which, if you have all of that, you can actually make a product. Then they will be very eager to figure. So the entire know-how is there. Otherwise, patent may be one small thing, like now as I said, switching scheme, right? But then the control scheme is not novel, right? The topology is not novel. So that way, people will actually, they may still take the patent, but they will not get the full solution. So if you can have your own patent portfolio, that's what the industries want to do, right? I have not mentioned about industries because we are talking about academic institutions, but what the industries do, like let's say this Texas Instruments, Intel, they will try to get the entire patent portfolio. So suppose they want to get a, some chip on the mobile phone, right? So for making that chip, all the patents that are needed, they would like to own, right? And that is where, as I said, sometimes they would like to own the patent, which is developed by an academic institution. An academic institution can negotiate, right? They can give the ownership because that company would like to own. As a company like Apple, they will not work on any patent other than theirs, right? So suppose some academic professor has smartly developed one small piece, right, which they need, they will take the ownership by giving him the money. Right? So if you are one of the lucky, sometimes you will make those millions, but not all of us, right? So as I said, and this is also very important. The student who is filing the patent, student or students, they get trained in writing patents. And these days, as you know that when industry is taking our PhDs, so many of them will be going to industries or they will even become academics again, they will do the same thing that you are doing today, making students write patents, they will have their students, right? So then they can train their students and they will have their own ability to, they will know how to prove their own work in perspective and how to write patents. This is again a very important capability that they need to have, so they will have that. So some of these things, so that is why academic institutions, we should try to encourage patent filing. And this also the last point. So once you identify the innovations, right, then you can actually see the impact of that innovation in the community, right? Either in your own domain or sometimes you have social impact somewhere. So that innovation, sometimes innovation these days are not only in terms of product, innovations is happening in services also, right? Like the way that we book our cars, Ola, Uber, this is a service level of innovation. This was not there earlier, right? Similarly, housing, you are going to buy a house, so you have a new way of procuring the houses, right? So and people are making money by developing platforms, software platforms to help people buy their products. So similarly, so many other things, including logistics management, how the trucks are moving across the country, right? How to keep track of them and ensure that your fuel is still optimized, timing is also optimized. So there could be innovations in that respect also, and these may be having even wider impact. So once you have identified those innovations, you can actually measure, how much is the impact, right? Sometimes, as I say, it may not be in rupees or dollars, but it may still have a societal impact, right? Okay, so finally, some topics for, we have discussed much of those. So fees, there are application fees, attorney fees, annuities. So as long as your institute is giving, so you can relax. It will not come out of your pocket or your project. Okay. An Indian patent versus this point I've already touched, whether you should go for Indian patent or US patent. So sometimes there is a need. If you really feel if you are working in an area which is a global, playing into the global marketplace, filing an US patent also makes sense, right? But filing a US patent, as I said, is about $10,000, which is more than 8 lakh rupees. So there you have to be careful, and you have to see that there you have to really see the commercial potential of that. Or you can do that. You can file an Indian patent and we can file a PCT. So at least it is recorded in your against your name in the PCT. So we can think of those things. Commercialization of patents. This is again a very important issue, and for academic institutions it is very difficult to commercialize, actively commercialize, because this would require a full office. Firstly, you need to have lots of patents, patent portfolios preferably, and then you need people who will actually actively try to market them, right? So it's difficult, and even for industries, they what they do is they do their they have their patents in their portfolio, and they just use, say, let's say Texas Instruments. So it has so many patents in its portfolio, and it makes chips using those know-how, right? So they are making money directly by their own from their own patents. But academic institutions are not product-making companies, right? So they cannot earn money like that. So there have been one or two companies which have been telling academic institutions that, okay, you make your patent, give your patent to us, sort of, let us take custody of your patents, and then we'll try to commercialize. We'll put people, and then they will talk to industries, and then try to find out where it can be applied. But this has not been very successful, this model, and the institutes are also reluctant because there is no guarantee that it will give you result, but it may bind you up somewhere, right? So this is something which right now I do not know what is the best way of doing, right? And another thing is that there is also one more point. Let me give you some of the negative points. Negative point is like this. So suppose Professor Singh has this patent, innovative switching scheme, but General Electric is using it without giving a paisa. What can he do about it? Firstly, he may never know that they are doing it. So, and then suppose he comes to know somehow, some student somewhere. Even then, what he will do? So he will have to sue the company, right? That's not easy. It also costs money. So you will have to come to the Dean R&D saying, "I have a patent infringe kar raha hai. Let us go and sue them." That's also very unlikely, right? So those things are there. As academics, we don't have that wherewithal, that fighting power, right? So typically these will be between the companies. So one company, typically, you have heard about the patent war between, I think, Google and Apple or some companies like that, right? So for smaller companies and bigger companies, right? So what happens, a bigger company, if they find that some smaller company has a lot of useful patents, they will buy the entire company along with the patents. So patents being part of the property, intellectual property is part of the property of the company, they will get everything. Right? So fortunately they cannot buy IITs, but they can use it without telling us. So let us. So what I am expecting is people, they do ethical businesses, they will not do it. And most companies, I am taken name of GE, not that I know that they are doing it, but one thing as an example, don't take it literally. Any company making use of the patented know-how, right? So, I mean, either you have to sue them or to accept it. And patents, they can be classified in different ways, and in this matter, the Indian law and US law is a little bit different. In the US, you can actually also patent an idea. In India, you cannot, right? In India, you can easily patent products, because our patent office knows what are products. Something will be there on your desk or on the field, right? They can see it, right? And processes also can be patented. That is, suppose you say you have a novel idea of producing ethanol, right? Then what is the process that you have used to get that thing? You can patent that, or you can also patent a system, like in electronics, you have a circuit board, right? Where so many chips will be there, and you have connected them in some novel way, and then you have developed, let us say you have developed, let's say, a temperature control system of this room. So it is a system, right? So that way we can we have to place it, and if the patent lawyers, patent attorneys, patent agents will tell us, right? So you feel free of going out with the novel ideas to the attorneys, and they are supposed to tell us, which way it has to be presented. They will tell you some of the how the titles of the patents often will look very funny, right? Like systems and processes for making ethanol and the methodology thereof, like that. Okay. So, and also when you are doing the patent write up, you have to we sometimes we just describe what all little bit we have done. Often we lose the general picture, right? So we say that okay, this will work for some 3 elements, right? What is possible is that you may work with 5 elements also. So you must keep it broad enough so that you capture all other things. Or you say that you have made it using aluminium. Maybe it will also work with copper, right? Then you have to say that no, a conducting material such as aluminium, copper, dot dot dot. So you have to generalize it. Otherwise, you make something very novel using aluminium. Another company makes the same thing using copper. They will not. They can claim that they are not infringing on you, right? Because you wrote clearly, you wrote aluminium. So copper is not aluminium, so they will get away, right? So while you are writing, you must write in the generalized way. And this is also very important, especially for the students, right? So in fact, I have gone to some labs and I have asked them, and I think they are doing, especially where they have already filed patents. So you should maintain a notebook, right? Which will keep a log, what all you did, on which particular day you decided to mix, material A and material B. Should be, if it is there on your notebook, sometimes, and then another lab, another group is doing it, they will patent attorneys and patent examiners can check those dates. They'll give your lab notebooks. They'll say no, they have got it on 7th of August, other one has got on 9th of July. So the 9th of July gets the patent. Right? So keep doing that, keep writing it in your notebook. Right? So these are some of the points, and I think I'm done, and here are some of the links you can see in Wikipedia, and of course today during the workshop you will learn a lot more things, right? I think some of you are very struggling to take the photograph, not necessary. I think in R&D can circulate, to all the members. Okay. So with this I conclude. So if you have any questions, I'll be happy to answer. Take the mic.
If something is published in the journal, after that we cannot find it in the
No.
Similar question. We published a paper a decade back almost, but it has a good idea. But public is not possible to.
No. So don't. So whatever is gone is gone. But you must be having new ideas there.
But as you said, sir, within half a year,
6 months.
A publication of paper.
No. What I'm saying is that you go through that.
Yeah.
I'm sure you will get more new ideas related to that.
Maybe similar.
I mean derivative. What you call as derivative ideas. So often they are those things you can suddenly patent.
Thank you.
And the original thing will be embedded in that. So at least in a way you are building on that.
But actually, we published some papers, and thereafter some people, some organizations contacted, and they were trying that they were persuading us to file this patent. So probably it was within 6 months.
Right.
I don't remember exactly.
So, but if some other company wants it, they can still use it, and you can still charge them if they are willing. They may not need a patent. You will give their know-how.
Yeah.
So, if they are willing, of course, if it is decade old, then it is doubtful. But I think so. As I said, people in academics and research, they will get hundreds of ideas, So some idea is lost, take it as lost. Think of the next idea.
Sir, actually, let me reveal it. There was a student of mine who was in an MBBS, he was doing Masters of Medicine and Technology at IIT Kharagpur. He worked with me for a year or so. So he gave me the paper and it was reported that the pressure in the esophagus, in the lower esophagus is high. So mathematically it was possible for me very easily to formulate. Actually if the weight and volume increases, the pressure will rise. And of course it is required. So this same idea we applied for switching juice from sugar canes. So sugar cane juice extracting machine can have this idea. So this paper was published some 2-3 months back. So as you have suggested, I would like to file a patent. Thank you.
2-3 months back, I think we will still find out from the patent attorneys.
So, thank you.
Mike Lidhi.
So what will be the advantage of filing a patent in US or doing it with PCT versus filing on Indian patent?
So PCT is not a patent. It is a recognition that you have a patent in India or whichever other countries, member countries, right? You see why US patent. So why everybody is doing US patent is still because most of the big companies, they have their headquarters in the US, right? So that is why having a US patent has advantage. So, generally from India we only file from India and US. So because the company, it is related to companies, and also many US companies are in India now, right? One could have said that same thing with China, but China does not respect intellectual property. So otherwise, India, China, US, Japan. Japan is also a country. Sometimes, basically, I'll tell you. So, which and how do you decide on in which country you are going to sell? So you have to see where is your market, right? So in which country they are producing the things that you want to market. Right. So if they are produced in India and marketed in India, Indian file is Indian patent is enough. But if you are producing in US, then just filing a patent in India will not help. So you have to make them produce, file a patent in US. Right. US companies, if you work with, they will always make you file in the US. So often, these things depend on the collaboration or the companies with which you are trying to contact. Because business is something we are not the best experts. So basically, where from they are seeing the business, there you have to file in that time.
What about the thesis of the outgoing students? Because more details will be in the thesis, maybe PhD, maybe master.
Yes.
So it goes in the public domain. So patent is in process.
So there is a mechanism generally. I don't know whether here it is explicitly there, but many IITs you can keep the examination can go on, but you need not publish the paper and publish the thesis. So don't put it in the public domain for a certain period until the patent gets filed. Yes.
It's a very nice topic. You mentioned that if patent is awarded, can be considered as a
Publication.
Instead of that, it's my personal opinion. If patent office publish that application patent, then we can consider as a, because they give the journal, patent office journal, page number, year of publication. So I will request you for that.
We will consider that, but typically, what happens is that after examination, after publication also, based on examination, it may not get accepted. So there is still one more stage left.
So because to get a patent to be awarded, it takes 4-5 years, 10 years.
Yes.
It's quite late for the students also for the faculty.
Right.
thing is that if institute funds do not permit for the applications of the US patent or PCT, my sincere request will be there to give the NOC. If faculty would like to manage the funds from somewhere, so that they can go directly.
Yeah, NOC can be considered, right?
Intimating the institute that Indian patent has been filed, then we are ready to go for the.
No, typically US patent will be filed by US companies only. So if US companies are willing to file a patent, why should we let them file and get all these things? So it will be a matter of negotiation, right? So suppose some US company is telling you that you just give NOC, I will file it and it will be mine. Then you have to be careful, right? Then you have to decide whether by spending 8 lakh rupees we can actually earn much more. Right? So we can do that, but not just like not just by NOC. Maybe against a fee. We said, okay, you give us this much, then you can get some kind of non-exclusive.
Let's say Indian file has been, Indian patent has been filed. Let's say our funds is not permitted. Let's say $10,000 is very huge. If the inventor commit that, okay, I will talk to some industry, they would like to give, things will be there with the institute, like earlier. And only the NOC required to give.
Rights will be with the institute.
Institute or the inventor will be there.
No, it will be with the institute only because if the Indian patent is with the institute,
The institute that will be there also.
inventors have their own right also. I think 60-40 ratio, some right is there.
Yeah. So similar hardware mechanism is there.
Right.
One more request will be there. Let's say we are the inventor. Whenever we found that the inventor name is not there on the certificate.
That is because we don't pay. There is some additional payment required to have the. Yes.
So that mechanism, I will sincerely request.
Those things we will figure out. Those are no. I think actually attorneys sometimes miss that, or they feel that extra paisa lagega. So they skip that. But I think it may not be too much of money.
Because my students is telling that, let's say sir, I will be applying for somewhere. When I will be producing the certificate, my name is not there. So digging out everything, taking the something is.
I know. So in the patent of IPO file, it will be there in the website link. It will be there. But I agree, is the list of inventors are not there sometimes.
On the certificate name is
Yes.
not there. Other IIT is just giving the award to the inventor. Okay, the inventor name will be there, and institute is paying.
That is a, I think, gap and slip up of something. This can be easily incorporated in the names consistently. I think Dean R&D wants to say something.
Actually, just clarify about not having names of inventors patent. Earlier we had only two avoided. So we didn't realize that for giving names we have another form to be filed.
Yes.
There is a separate fee form.
Right.
So when we gave tender for this patent attorney, patent agent, we didn't include the last one. So that's not, it's small fee, I think 3,000 or something.
Yes.
Then we said that only the last one, if you want your name, you pay from your project or DPDA. When we do tendering next time, it will include.
Yes, let us have a mechanism which everybody understands.
Well, you spoke about the challenges of commercialization, and you said that there is no authentic company also. There are some, but their reliability is in doubt. Is there any government organization which takes into account this transferring of technology from the patent to the industry? That is my first part of the question.
As far as I know now.
Okay. And the second is, for an example, like I have a patent for a cigarette puff, that is the filter. But can the institute, with its limited resources, go to people who are making filters or use their website so that people who are into the business of making filters for cigarette or for some other application, they can come to know that these facilities are available or this patent is available, or they directly go to the patent site and they can get information easily from there. I mean, what is the easy way out of commercializing our products with the limited resources at our disposal.
No, actually there is something called business development, which is not yet there in our institute. But we are thinking of those things, so I think we'll have something, maybe may not be too much of a resource, maybe one person or something who will be responsible for such commercialization. We will work with the faculty members, understand the possible opportunities for commercialization and work on it.
So, sir, two faculty members may not be knowing, so this is right opportunity to tell them. We also have MOU with patent wire for commercial. From time to time, they have a magazine IP Bazaar. So they select few of our patents where they find some commercial value and publish in their application. So when some client comes, they contact the concerned faculty. Although we don't have a very strong setup for commercialization, but it's going on in smaller scale. And if anyone, any faculty thinks that they have very high commercialization value, you can contact with patent wire and they will certainly try to publish in their 1990.
Good.
So I have one point to add to the previous question of yours, right? Good morning, everyone. So the new rules have been notified by the Indian government, wherein those who have missed getting their names, the inventors, on the certificate, they can now formally apply for a different, in a different role, that to obtain the certificate of inventorship. So earlier we used to file for the Form 8, which Dr. Saab just mentioned. That was to be filed before the grant of the patent. After the grant, there was no provision, but now there is a provision. So those who want, they can just request to the coordinator, sir, and we can take up those requests.
I'm
Thank you.
talking about money. Paying the money of 2,900. I'm just talking about money. You can request, that's it. Email only. But what students, those who are, we give the idea to the students.
Yes.
Students what?
Yes.
Student will be proud. This is our job.
Yeah.
But how they will be proud if their name is not there on the certificate?
Yeah, no, the few requests we also received which were after the grant of patent, so I'm addressing all of these.
I know.
Funds, I think he is the best
I
person.
know, I am acquainted for last 20 years. I know the each and every step. I am telling about the students,
Yes.
how they will feel pride. So
Thank you.
if
No, but now if the new rule is, I was also not aware, if the new rule is there, I think the patent granted earlier, say 10 years back, can also be included. Very good. So now it's up to us.
we have to pay 2009.
Yeah. You should be knowing the exact figure. That's very good. No, this is what I understand fully. We got missed out in the early stages.
So the official fee is 800 only for inventors. We can take that call, offline. We can consider that. Don't worry.
Thank you, sir. This is related to the technology transfer. So what I know from my experience, pretty much 3 years back, when patent was granted, I was and one startup was ready to take it. But then institute said, okay, they are giving very small money, so we cannot actually go with this. So my humble submission is that it should be upon the PI. How much money they are giving, if the PI is satisfied, then we should actually move forward. Then actually I got demotivated.
No, I understand. Well, let us leave it behind. Let us think fresh. Going forward, let us filing of a patent and commercialization. Those are two different aspects. Which will go on its own.
Okay. So my second request related to the patent filing through the ICMR. When we go, which we already discussed. So when we go through the ICMR, the issue comes up, the right will go to ICMR.
Right.
And it takes a lot of time as well, and there are other issues as well. But ICMR has also given the freedom that we can file from our side, and ICMR will be the co-inventor. That I feel is the better approach.
Yeah,
So,
we can go for it, right? Yeah, we can go for it.
But I think that institute said most of the time, because the money comes, then go through the ICMR.
That's the two funding agency are endorsing that they would be co-patentee in any patent file from funding. And we are not stopping. we have been permitting with ICMR. I don't recall any case was stopped.
My main to say ICMR should be co-inventor. We should file from our institute,
That
but
is
we
also
are
possible.
actually preferring the other approach.
No, either way it's
Right.
possible. If inventor is requesting that it should be filed through ICMR, that is also possible. And it's also possible to be filed from our institute. Only one details we can discuss with our agent. When we include any bigger entity in our patent as one of the patentee, the cost of everything becomes many-fold higher. For example, if you have a industry as co-patentee, then cost of everything becomes 4 times, 5 times.
Is
Then-
it?
Yes, they will tell you. Any bigger entity.
I didn't know that.
Yeah, any bigger entity patent cost becomes higher, and then it's not covered as per our rate contract. So then.
No, we'll figure out. This is a commercial point, but I do not think that is true.
In case of ICMR, I asked the wrong thing.
So when we add the co-applicants, the fees does not go up. That remains same, official as well as ours. The only challenge would come is, whenever we meet, as he rightly said, when they are co-patentee, they are co-owners basically. So whenever you commercialize, you need their approval as well. So they may have discrepancy and they may have their own discretion to sell it on a certain price. They may hamper the negotiation this thing, because every negotiation round would require them to be party to it. So that at that stage it will affect. But till the grant or till that, nothing would happen. Once we have the POA, we would take all the actions. But yes, there may be some directions from there that whenever you process something, you take our permission as well.
Yes.
Then but the cost wise it remains same, no change.
Take
This
it,
is for
take it.
large entities, sir. This is for large entities. So ICMR, I think, falls under the same category that.
Now, what is a large entity? I did not know.
No, actually, so what happens is there are multiple slabs. There used to be multiple slabs. One was the individual and SME one individual
I see. This
category.
Indian Patent Office.
Yes, the official fee slab I am talking about. One is the middle slab and one is the highest one. Now there are only 2 slabs, wherein large entities pay a 4 times fee, and the small entities and education institutes pay a lesser amount of fee. But since the ICMR is also a government entity, they would be eligible for the lower slab. Yes, at that time. Previous slab it was higher, but now it is coming in the lower slab.
The IDFT of foundation, we had certain patents. Hence, that when we were trying to include in our patent, the question was to give a certificate for MSME, which we don't have in IDFT of foundation.
Yes.
So initially, we were struggling that it will be considered a small entity or large entity.
For that we need an MSME
So
certificate.
we don't have MSME certificate, so
Yeah.
it's considered as large,
Yes.
although it's a very small unit. So sometimes some technical.
No, these are glitches.
Yeah, but
But I am still not right here. So let me ask you. So, is there a distinction between co-applicant and joint owner? So, if there is a joint owner, then this rule will be applicable. This extra payment will be required. Big, large entity joint owner.
If the large entity is the owner, then you have to pay all the back-end fees. जो भी शुरू से
No, it's not. It's a joint owner.
Yes.
Same-
You have to
same-
pay balance fee. Yes.
Same rule will be applicable.
Yes. So if both the joint owners are eligible for the lower slab, then no fees is required. So if IDEP gets this MSME certificate, then there would be no balance fee which we need to be paying. For under section 8, MSME is not the right term.
Yeah. So understood. So I think ICMR will not be an issue for funding.
as long as.
And if there is a private entity, a large private entity, let me say, they will be willing to pay because they have to pay if it is their own patent.
Then absolutely it's not a problem. We can file from our institute also.
Yeah, that we can rework. Maybe we'll discuss a little bit more detail and then we'll work it out.
Sir, I have one question. So when we file patent, we use certain figure and text when patent is published. This doubt I always had. If you use same figure and text for our publication, would it be considered as self-plagiarism?
No.
No? No. Okay, thank you.
Self-plagiarism, that anything will be there, But I think patent, nobody will take cite a patent document saying that it is plagiarism. Especially, as far as I understand, plagiarism, of course, the type of plagiarism people talk about is the textual, copying text from there. There is no issue with that. But diagrams also, I don't think. I think never came across that kind of a situation. Right, you cite it. Cite it. Okay. Right, with self-citation, appropriate documentation, you should be able. Yeah. So, shall we close now because coming to the end of the session. Okay, one last question.
Yeah, thank you sir for the nice talk. Since coordinator patent office of IIT which is also there and PTFR is there, I would like to bring one particular point because it has been told that sometimes faculty don't respond in time. But recently it happened thrice with me that FER response had been asked by the patent office much earlier, and the emails to the faculty have been sent 2 days or 3 days just back to respond by next day or next to next day that we have such and such filing day. So I don't know why it is happening because they have well in advance about the notice that when FER is to be filed, and it should be a given proper time to the faculty to respond those, because those are tricky questions, and especially when you mention when your student has gone to the postdoc for doing abroad, finding that the student and again doing that thing will not be possible in 48 hours, and it has happened thrice. And I wrote email to the patent buyer as well as the R&D coordinator this one. I did not get any response on that, and the third time also the same thing happened. So since patent buyer office is also there, that's why I am mentioning this particular point.
No, we'll look into that. We'll discuss. Please, no, maybe 1 or 2 exception cases may be there. Some reason may be there. It happens. It may happen occasionally, we can always consider that.
Thank you, sir, for your enlightening address and for sharing your valuable perspectives with us. As we conclude this inaugural ceremony, I would like to invite Professor Ranjit Mohanty, Professor in Charge Administration, to present a token of appreciation to Professor Amit Patra. With that, we officially inaugurate this workshop. Thank you all for being here and for your commitment to educational excellence. I would request all of you to please join us for the high tea.